All right, good morning. I see that we should be live now on YouTube. My name is Steve Hill. I am designated as the presiding judge of this panel of the Court of Appeals. We've got 3 cases set for oral argument today. And I am pleased and honored to be serving on a panel with 2 distinguished judges. Judge Tom Malone, who is one of our most senior judges on our court, and Judge Richard Walker, who is a veteran of many judicial campaigns, being a longtime district judge and now a senior judge with our court. And I'm happy to be with both of them on this case. The first case that we have this morning is 120054, Denise Ann Roenne, Jeanette Marie Miller, Mark Benton Miller, and Justin Miller, appellants, versus Lawrence Bradley Miller and Amy Starr Miller, appellees. I would ask counsel for appellant to please enter his appearance.
Your Honor, may it please the court, Craig Urich for the appellants.
And Mr. Urich, do you want any time for rebuttal?
If I could reserve 10 minutes, Your Honor.
10 minutes. Okay. And could I have the appearance of the appellee's counsel?
May it please the court, Your Honor, the appellees appear through counsel Todd Powell.
Thank you, Mr. Powell. We have set this matter for 20 minutes. Counsel, I can tell you that we have read the briefs in this case. We have received a pre-hearing memorandum from our research staff concerning this case. And we may or may not have questions for you as your oral argument goes. It's been our experience in video conferencing of oral arguments that there has to be some accommodation made for recognition of a question. So be alert. If I have a question, I'll try to raise my hand or something like that so you can then pause your argument and I'll ask a question. That way we won't talk over each other. But we will begin with appellant's counsel on a case that I find very interesting that centers on a testamentary trust. So, Mr. Urich, you may begin your argument.
Thank you, Your Honor, and may it please the court. Your Honors, this case revolves around one simple question. How do we interpret a trust that grants, quote, unlimited discretion to the trustees? We would argue that the law is clear on this, both from the statute and from case law. It's clear that the fiduciary duties still exist and that the trustee must exercise his discretion in good faith and consistent with the terms and purposes of the trust. Here, Sonia Miller Weller, the settler, cannot have absolved the appellee, Brad Miller, of his fiduciary duties or of his liability for squandering all of the trust income and assets on himself and his wife, nor did she intend to do that. To say otherwise and rule that unlimited discretion allows a trustee to do whatever they want and to self-deal makes mockery of the fiduciary duties and of the Kansas Uniform Trust Act. It was not Sonia's intention to do so. She tells us in her trust that the purpose of the trust was, quote, for the primary benefit of all of her children. She also says that Brad was to discharge his duties in a fiduciary capacity. Of course, as we're aware, fiduciary duties include things like the duty to administer the trust in good faith, duty of loyalty, duty of impartiality, the duty of prudence. We would argue that all of those were broken by the appellees in this case. Unlimited discretion does not mean that you get to do whatever you want. In the Schartz case, which we cited, we're told that broad grants of discretion must be strictly construed so as not to defeat the purpose of the trust. In the Jennings case also, there was a broad grant of discretion, but still the court continued to favorably cite references to the fiduciary duties. And finally,
Counsel, I do have a question for you. It seems to me that when the trial court looked into this matter, the court took into account the disposition of this lady's estate in the will. And that influenced, it seemed to me, the trial court's decision. Would you speak to that?
yes, Your Honor. The position we would take on that is that the assets that were transferred in the will, the farm assets, those sorts of things, are not the assets, and in fact are not related to the assets in the trust. For example, the trust consisted primarily of oil or mineral rights, I should say, which were on land that was completely different than what was disposed of by the will itself. And so it was not the purpose of the assets in the trust to simply support the assets that were passed through the will.
But I think Mr. Miller, the trustee, emphasized in his testimony that Mother wanted me to keep the farm together. So he used the money from the income of the oil income to pay for the farm expenses. Is that correct?
I know, Your Honor, that there was testimony to that effect, and maybe she did want him to keep the farm together. In the first case, that would be parole evidence. That was not part of the trust documents or the will. The trust documents make clear that the purpose was to benefit all of her children, not to keep the farm together. Secondly, the farm that was kept together is not the same farm that was passed through the will, because there was land that was bought and sold in that transaction. So the farm that exists today is not, in fact, the same assets that were passed through the will.
If I understand correctly, too, some of this money was used to buy or pay for a farm for milk. Is that correct?
I'm sorry, Your Honor, you cut out at the end of your question.
Is it true? My understanding is that part of this trust assets were used to pay for a farm for Amy Miller. Is that correct?
That is correct, Your Honor.
Is she named as a beneficiary?
No, Your Honor, she is not. She is the wife of Brad, who is named as a beneficiary, but she is not herself a beneficiary. Although I believe Brad testified at trial, at one point it sounded as if he thought she was. And he backpedaled.
Does the trust grant the trustee the ability to new beneficiary?
No, Your Honor.
Does the law permit that?
Your Honor, I will say that is not something that I researched specifically, but it's my understanding that it would not.
If I understand your position, is that was there a need for an annual accounting?
Yes, Your Honor. The trust specifically says that there will be an accounting annually.
I thought there was language in the trust that said if requested.
No, Your Honor. The language in the trust says that there's to be an accounting each year, and then there's language that says that it's to be available for inspection. And so we would take that to mean that it has to be generated and they have to be notified that it's available. It may not have to actually be mailed. Perhaps they get a notice that the accounting's available if you'd like to come look at it, but that an annual accounting was required by the trust.
And were any accountings requested by any of the beneficiaries?
To the best of my knowledge, Your Honor, there was some testimony that there were informal requests made. I don't know that any formal requests were actually made, but again, we would take the position that they did not have to request them because the trust obligated the trustee to make them.
And I have a couple of factual questions for you. As I understand it, over the years, the income from these leases, approximately $2 million. Is that correct?
Correct, Your Honor. And if I could, I should clarify a point there. There are a couple points in the brief where there's a editing remnant where we still have the 1.3 million, but the correct number is the 2.2 million that's detailed in paragraphs 12 through 15 of our brief.
All right. And now those leases have been disposed of. Is that correct? Through sale?
Correct, Your Honor. There are no assets left in the trust.
And that money went to Mr. Miller. Is that correct?
Mr. Miller and his wife, correct.
Let me ask you this. Did any of the appellants receive $1 over the years from this trust?
No, Your Honor.
All right,
Okay.
go ahead.
Okay,
You've got about 2 minutes.
Okay, thank you, Your Honor. As I was saying, the Kansas statutes also tell us that even with broad granted discretion, the trustee must exercise his duties in good faith, consistent with the terms and purposes. We would argue that he did not do that and that each of the fiduciary duties were broken. It was not administered in good faith because of the self-dealing failure to report. The duty of loyalty was breached by putting his self-interest ahead of the others. Impartiality was breached because he treated one beneficiary himself different than the others. And prudence was breached because the trust assets were disposed of to be used on non-trust property. And while we're not abandoning any of the other arguments in our brief, and we maintain and support all of those arguments, the crux of the case is really that the appellees violated their fiduciary duties and the terms and purposes of the trust. Over the years, as we've said, they took all of the income and assets and transferred it to themselves for their own use.
Before you finish your argument, I do want you to speak to the advice of counsel portion, if you would.
Okay, Your Honor, as far as the advice of counsel goes, we would simply take the position that, you know, as in pretty much any other part of the law, if your duties are clear, simply having a lawyer tell you that you can do what you want does not change and cannot change what the statutes and the case law of the state say with respect to what your duties are.
Thank you, counsel. I think you've used your 10 minutes and
Thank you, Your Honor.
you still have your 10 minutes in rebuttal.
Okay.
All right, Mr. Powell, let's hear from the appellees, if you would, please.
Thank you, Your Honor. And it is my intent, Judge Hill, to address your questions from the appellee standpoint. I intend to go through that as I go through my argument, but if Your Honor would like an earlier discussion, I'd be happy to do that.
No, go ahead. Proceed
okay.
with your argument.
Thank you, Your Honor. Your Honor, what the plaintiffs are asking the court to do is to ignore the terms of the trust and to ignore the law. Everything that counsel has argued this morning and everything they briefed and everything they argued before the district court basically ignored the fact that Brad Miller was also a beneficiary of this trust. And it ignored the express provisions of the trust. And it ignores the fact that Kansas law, all of the prudent investor, the rule against self-dealing, all of that contains caveats for complying with the terms of the trust. And so what counsel would have this court do is basically adopt a rule that says, even though the primary purpose of trust law is to enforce the settlor's intent We can't do that in this case because that would result in one beneficiary being benefited over the others. And clearly, if you look at this trust instrument, it allows for that. The result here wasn't equal, but it wasn't designed to be equal. If we look at the facts of this case, I think that will clearly shed light on the intent of the settlor, which, as the judge below found, was clear. Yes, Judge.
The question that comes to my mind with such an argument, let me put it this way. Is this a sham trust? Is it a trusted name only? Since he was also a beneficiary, he could do what he wanted with this?
Judge, that's what the argument has been. I've referred to it as the illusory trust argument, that they've made this argument that because it gives this discretion, somehow it doesn't have any force and effect. They've not shown any law that says that a sham trust or an illusory trust is actually recognized in Kansas. I think in order to find that, Judge, you would have to disregard the intent of Sonia Miller. And I think according to the law, this court cannot do that.
What are we to take from these statements in the trust itself that it's for the benefit of all of her children, and then skipping a generation to the benefits of her grandchildren? What are we to ignore that language?
I think if I could address the generation skipping issue first, I think that's completely inconsistent with the language and in the intent of the trust. When she references the grandchildren, she talks about if there's anything left when there's no surviving children, and then it's for the benefit of the grandchildren. And I would note, incidentally, that if that's actually the argument of the appellants, then that contradicts any claim for them to entitlement from the trust. So I think the generation skipping thing, I don't believe is an issue. I don't believe this is a generation skipping trust. Clearly, the Sonia Miller wrote in the trust that yes, it's for the benefit of all her beneficiaries, but then you can't ignore all the other language, which counsel would have you do. You can't ignore the language that says the trustee is given uncontrolled discretion to give any and all principal to any or all beneficiaries, and that his decision on which amount of principal or which amount of interest is to go to which beneficiaries is final and conclusive and cannot be challenged. And at no time does any specific beneficiary have any right to either the income or the principal, and it's all in the discretion of the trustee. So in order to say that for the benefit of all my children, that is preeminent over all the other language, I think you would have to ignore the totality of the trust, which the law tells us is how courts construe trust instruments.
In your view, then, that's a meaningless statement.
I don't think it's meaningless. I just don't think it has any more meaning than all the other trust language that gives the trustee the discretion. And let's look at, when we're looking at the intent of Sonia Miller and trying to determine whether the court below correctly determined that this was an unambiguous expression of intent, no need to resort to parole evidence. Let's look at the background and the facts. When Brad Miller was in college, he was a young man, and he was asked by a sitting district court judge to serve as a receiver in his parents' divorce action. And as a receiver, he was to manage the farm property. And in that capacity, he came to certain observations and conclusions about how the farm was run and how it was to be run if it was to be profitable. So no other sibling, there were 5 Miller children. None of his other 4 siblings were asked to be the receiver. And then the last will and testament of Sonia Miller was drafted, which contained this trust that we're talking about, this testamentary trust. He was named the executor. No other Miller sibling or child was asked to be executor. He was named trustee. No other Miller sibling was asked to be trustee. He was given a fee simple portion of the farm real estate. No other Miller child was given a fee simple portion of the farm real estate. The only other sibling was Mark, and he only got a life estate for his life only. In fact, there's a provision, and Your Honor asked about the terms of the will earlier. There's a provision in the will that says, at no time shall any of the other beneficiaries, which would be Jeanette, Denise, and Justin ever come into possession of farm property. And if they do, then it's automatically to revert to Brad. So if you want to look at the intent of Sonia Miller, clearly we can see the intent to put Brad in a position of responsibility, to give him the utmost discretion, and in fact, to benefit him more than the other beneficiaries. And again, that's not equal, and it's not designed to be equal. And I think if this court were to impose some sort of equality standard or fairness standard, that would just run afoul of the terms of the trust. Yes, Judge Walker.
I guess I'll just be perfectly candid with you. The real issue I'm having is the same one that your opposing counsel raised, and that is fiduciary duty. Now, I realize that there was this broad language in the testamentary trust, but are you saying that essentially wiped away the fiduciary duty? Or if not, then how is the fiduciary responsibilities to all of the beneficiaries carried out? I mean, it appears to be, and I realize that the trust in effect created a self-dealing provision in there and forgiveness for self-dealing. But some of the cases and the arguments that I've seen say that even in spite of that, you have a fiduciary duty. I guess I want you to address that issue.
Yes, Judge, I would answer that by saying, I don't see how you can find a breach of fiduciary duty if the trustee relies on the terms of the trust. If your honors, if this court finds this is a sham trust, and whatever the consequences of that finding will be, I think that, I mean, I think your honors have the ability to do that, but I think it's kind of changing the rules in the middle of the game or at the end of the game. I mean, keep in mind, this was 25 years ago when this state document was created, and some 20 years after these decisions that are now being challenged were made. So all the law that I'm aware of says that a trustee complies with or fulfills his fiduciary duty if he or she complies with the terms of the trust. And whatever you think of this trust, I've not heard any argument or any statement that Brad Miller didn't comply with the terms of the trust. I think the arguments are they're too broad, they're meaningless, etc. But I think in order to find a breach of fiduciary duty, you would have to find he violated the terms of the trust. And when the terms say he has the discretion to give any principal or any interest at any time in any amounts to any beneficiary, or in fact, none of the beneficiaries, clearly he's complied with the terms of the trust. And I want, that's an interesting segue, I think, to discuss the relief that the plaintiffs seek. And I think clearly you'll see that any relief that they seek, if it was granted, would violate the terms of the trust. They want this either 1.3 million or 2.2 million, whatever it is. They want that distributed to the four of them, and that would ignore Brad's interest as a beneficiary. That would ignore taxes paid over the years. That would ignore our statute of limitations defense that because Judge Biddle said this document was clear on its face and unambiguous, he didn't get to our statute of limitations defense. But again, we're talking about decisions made over 20 years ago. So if this court, or if it were to be remanded and the lower court were to say, yes, we need to capture all this income that's been paid out and recapture these oil leases or oil interests and then pay them out to these four beneficiaries, that would be a direct violation of the trust, because there's no language in the trust that would either require or in fact allow that. Another relief that they seek is this $2.4 million judgment that is for 40 years into the future. There's absolutely no foundation for that requested relief. And doing so again would create some remedy or create some right that the trustor herself did not do. So again, judges, I understand what you're saying. This doesn't, this isn't equal. This isn't, in the plaintiff's words, fair, but it wasn't designed that way. And we didn't get into the intent of Sonia Miller because this was declared to be an unambiguous document. That is an option of the court, but I think the court only has three options. There's a lot of things that plaintiffs have asked for, and so I want to make sure, and I don't want to be presumptuous, but I do want to make sure that the court understands the defendant's perspective on what your actual options are here. Obviously, you can affirm, you can find this is unambiguous, even if you don't agree with the terms. The law is pretty clear. You can't rewrite a trust just because you don't agree with it. And so disagree with it, that's fine. but I don't think that entitles the court to rewrite the trust and to completely disregard the intent of the settlor, which you would be doing. So I think the first option is to agree with Judge Biddle that this was an unambiguous document and affirm. Or you could find it's an unambiguous document, but Judge Biddle engaged in some or committed some other reversible error, which I don't think the plaintiffs have proven. Or you find that this is an ambiguous document and it returns for fact finding on the settlor's intent. Again, from the entire document, from the four corners of the document, from naming Brad as trustee, naming Brad as executor, giving Brad the fullest interest in the farm property, having statements that none of the other three children are to ever come into possession of the farm property, and if they do, it goes to Brad. Reading all of those things together clearly shows the intent of this settlor here. And again, it might not feel good, it might not feel fair, but can you honestly look at the terms of this trust and find that they've been violated? And Your Honors, before I close, if I could address a couple of the cases that were referenced and a couple of the questions, I guess, from Judge Hill that I think are important to address, and I'll start there. Amy Miller bought property that was formerly in the farm out of a sheriff's sale. There was testimony that she did it in her name only because the bank that was financing that transaction asked that it be done that way. There was another bank, there was a lot of evidence in the record of the debt that was on this farm property at Sonia's death. And so because of debt owed to other banks, the bank that was financing this purchase asked that it be placed in her name only. This was joint property. Her and Brad were married and are still married. This Russell County property is a marital asset. He's a co-obligor on the note and he's on the title. There's absolutely no proof that, or no evidence in the record that any trust assets went to benefit Amy directly. Now, I think we'd have to ignore common sense to think or to say that it can't benefit her indirectly as a spouse. I think you would make law if you said that any beneficial interest from a trust or an inheritance had to be kept separately and siloed and not benefit the spouse. Again, I think that defies common sense. But Brad Miller testified he didn't give any assets to his wife. So I think to find that is somehow a trust violation would ignore the record and would create facts that don't exist. And again, the sheriff's sale was in 1996. And so that would ignore the statute of limitations, and certainly the defendants who did not have an ability to do so below should have an ability to argue and present evidence on that statute of limitations defense. Addressing a couple of the cases, the Schartz case and I think the Jennings case that was mentioned, both of them are factually an opposite, and it's the most important distinguishing factor, which is the trustee was not also a beneficiary. And the Schartz case dealt with a third person trustee who made investments through his son's company to benefit his son. Clearly that was a violation of duty, but there was no provision in the trust allowing for that, like there is in this case. And with the Jennings case, that was a third party professional trustee, a bank, that dealt with investment of the major stock asset of that estate. So these cases are not factually similar. And again, you would have to ignore the fact that Brad Miller was a beneficiary and ignore the law that says with the prudent investor rule, that has a caveat for complying with the terms of the trust. The rule against self-dealing has an exception for complying with the terms of the trust. So if you were to elevate that law here and say, this wipes out any decision-making authority, you would have to ignore those caveats, and then you would have to ignore the language of this trust. With regard to the accounting issue, Your Honor, I don't believe there can be any argument that the trust stated that those accountings were to be made available. And the evidence shows that at least from 1997, no accountings were requested. The record shows there were a couple of inquiries made in 2009, 2010, but at no time were any accountings requested. The defendants testified that they put together an accounting for this case within a day. They could have done so upon request at any time. Most, if not all of these other siblings testified to some degree that they moved on with their life. And in fact, one testified that he read the first couple pages of the will, knew that he was disowned, and forgot about it. But some 20 years later was then brought into this case. And the issue of did any appellants receive money, there is some evidence that I believe the trustee testified that all of the beneficiaries received vehicles from the trust. Mark received payments. I think, he quantified them around $20,000. It wasn't clear whether it was from the trust or from Brad and Amy personally, but there was testimony that they were benefited somewhat. But again, there's no requirement in the trust. And in fact, it specifically says, at no time shall any beneficiary have any entitlement to any principal or income. And to find otherwise, again, would be to rewrite the trust. So, Your Honors, to close here, I just want to reiterate that the language cannot be ignored of the trust. The law allowing a trustee to follow the terms of the testamentary instrument cannot be ignored. And the ability of this court to grant certain remedies also cannot be ignored. We believe the district court was correct that this is an unambiguous document. It should be enforced according to its terms, which the law says is the primary purpose of trust law, is to enforce the settlor's intent. We ask you not to ignore the law or to ignore the language and to affirm the district court. Thank you, Your Honors.
Thank you, counsel. We'll turn to Mr. Urich for you've got your 10 minutes, but I do have a question for you. Counsel raised an interesting question, and I will just ask you, what relief are you asking for from us?
Your Honor, as far as relief goes, I will agree it's a confusing issue. I would guess my primary request would be that you reverse and remand, and it can be up to the district court to decide how to divide stuff up. Obviously, my clients take the position that because the trust was violated and the fiduciary duties were violated, that it makes the most sense to divide things equally. But, as counsel said, the trust does not necessarily require that. And so the district court is probably in the best decision to decide how things should be divided. The other question the other issue I would like to address, towards the end, the accounting language was brought back up. I'm looking now at paragraph 24 of Appellee's brief. The trust provided that the trustee shall each year render an account of the administration of the trust funds hereunder. The same shall be available for inspection by all beneficiaries at any reasonable time. We would assert that what that means is that each year an accounting has to be rendered, but that after that, it's available at any time for inspection. That seems to me to be the plain language of that portion of the trust. At the end of the day, Your Honor, we understand that the children were treated differently in Sonia's final documents. But at the end of the day, to affirm the district court's decision basically is to say that whatever was in the trust is Brad's because he was given broad discretion. If that had been Sonia's intent to just give him everything that was in the trust, then she could have done that through the will. And she knew how to do that through the will because that's what she did with the farmland. And so the fact that she did one thing with the farmland and the other thing with these mineral interests tells us that she had a different intent for those two things. And the trust tells us what that intent was. It was to benefit all the children. even if it's not to benefit them equally, and even if there is discretion, as the law tells us in KSA 58A 54, even with broad, unlimited discretion, the trustee still has to act in good faith, consistent with the terms and purpose of the trust. And clearly the terms and purpose of the trust were not to simply pass everything through to Brad.
Counsel, I ask your opposing counsel if this was a sham trust. I'll ask you the same thing. What is your response?
Your Honor, I guess I would say that it was administered as a sham trust, but that was not the intent of it. The intent of it was that the trust benefit all of the children, but it was administered in a way that makes it a sham trust because discretion was read to mean do whatever you want.
Counsel, I have one question also.
Yes, Your
if there is a remand, the district court would still need to consider the Appellee's statute of limitations defense, wouldn't it?
Yes, Your Honor. I believe the district court would consider that on remand.
Would latches and or waiver also be something that the district court could consider? I don't know if those were ever pled or not, but
I don't believe evidence was put on with respect to those, Your Honor. I think the district court could consider it, but we would take the position, much like the statute of limitations, that because no accountings were made and Mr. Miller is still the trustee, that the statute of limitations has not ran. And since those things weren't done, there's the latches period would require some evidence too, because no one was informed of what was going on.
thank you.
All right. I see counsel that will proceed though, but Judge Walker, evidently the thunderstorm in Newton is going on still. So we'll proceed and we'll just go ahead and conclude your arguments when you want to.
Thank you, Your Honor. Just to address a couple more points that were made by opposing counsel. Yes, it is true that Sonia treated her children differently. There was language that said the farm property was not to pass to the other beneficiaries. But again, this trust is not dealing with that farm property. And even if Sonia wanted the farm kept together, the farm portions of it were then bought by Amy, so it's not the same farm that it was. And again, if that was her intent to use this money solely for the purposes of the farm that she gave to Brad, she knew how to do that because she did it with the farm. She could have done it with these mineral rights rather than placing them in a trust. And perhaps, we don't know because there was no evidence of this, perhaps she didn't trust her other children to run the farm, but it's certainly a different set of skills to run a farm versus to receive benefits from mineral rights. And so it is perfectly logical to assume, and based on the plain language of the trust to rule, that what her intent was for the farm is not the same as what the intent was for the trust. The trust was meant to benefit all the children.
Counsel, let me ask you one final question, if I could. If you could summarize your view, what is the major error made by the trial court here?
Your Honor, in my view, the major error made by the trial court is to read unlimited discretion to mean that there are no limits at all. We would take the position that unlimited discretion in the trust means you fall back to the minimum that's allowed by law, which is spelled out in our statutes. And that was not done. And so with that, Your Honor, the appellants would ask that the court rule that, in fact, unlimited discretion does not mean that fiduciary duties go away. And we would ask you to reverse and remand. Thank you, Your Honors.
Thank you, counsel, for interesting arguments. We'll take everything under advisement and issue our opinion in due course. Thank you very much for helping us out with these Zoom arguments, and good luck to you. Stay healthy to all of you. We'll go ahead and ring off now.
Thank you, Your Honors.